guys, it's Kathy. I hope you're doing well. We had a good stream last night. We did. Well, and it's crazy that, you guys are here just a couple hours later. Go to bed. We're going to do Wisconsin today. We hardly ever do Wisconsin. So, we're going to do Wisconsin today. There's four judges that I can get from Wisconsin. This man, I don't know his name. This judge streams the most. The other ones are rare, like super rare. Judge Frost is by far my favorite of all of them. And I had to just delete a long Judge Frost docket because it was pretty boring. I loved it. I really loved it. But it wouldn't have gone well. This judge is not the most animated judge in the entire world, that's for sure. But this is Wisconsin. And I don't know where in Wisconsin it's like Manitowoc County or something like that. If you're from Wisconsin, just correct me in the comments. It's something like Manitowoc, something like that. But their accents are very light, very, very light. You can only tell they're from Wisconsin in a couple words here and there. But that's okay. The magistrate we get from Wisconsin, that woman who is just mad at everything, she has a really strong accent. I gotta get more of her. But here, let's go to this poor soul in Wisconsin. My dog's yelling at me. That looks really close, Linus. And I love when people who are not from the United States know more about the United States than we do.
Conviction on the defendant's record.
Oh no, it's not.
I did share that.
No, it's not where Brooks did what he did. That's not. I'll type it in chat as soon as I let my dog in.
Information with attorney Dade, as the court learned earlier today. And just to supplement on behalf of the agent, after Mr. Odegaard disclosed that he had been charged as a child, the agent did, in this case, attempt to locate any of the juvenile records, put out all of the standard requests that their agency normally does to try to get comprehensive and complete information in preparing a PSI. It's not that the agent ever learned that these records didn't exist. It's that she just simply didn't get a response from the records keepers regarding what these records entailed or what they included. And that is why they were not incorporated into the PSI. And all efforts were made by the agent to attempt to ascertain that information. The PSI, I think, is incredibly well written. It's very comprehensive. The description of the offense, I think, is taken for the most part from the criminal complaint. And then again, it's reiterated by not only the defendant's statement about what happened, but the victim's statement as to what happened. This would add just a few comments in looking at the offense. We know this took place on June 16th, 2025, in the early morning hours of that night. About 12:50 a.m. when law enforcement was dispatched to the Pine Cone. I think it's important to point out that the Pine Cone location where this offense occurred is a gas station that is adjacent to the interstate. It is a 24/7 open restaurant and truck stop. It is also one of the primary businesses on the gateway right into the Johnson Creek Outlet Mall. Now, I recognize that the outlet mall isn't open at 12:50 a.m. in the morning. This particular location is very active throughout all hours of the day, including these very early hours of the morning, which might be different than, say, a Goodwill or a Walmart. or some other type of business. I would note that law enforcement were called. When they arrived, the victim was still present. Other witnesses were still present. Employees who had seen things were present. What was not present? The defendant. He had left the scene as soon as he had fired off this firearm. The firearm was not left at the scene either. The defendant made sure to take that with him when he left. The defendant never turned himself in. Law enforcement had to track him down. And
yeah, that's what we're going into today, guys. It was Manitowoc, but that's where the commissioner, the magistrate is from, the one I was talking about. This guy is Jefferson County. I got them mixed up. But yeah, so this is Jefferson County, Wisconsin.
When they did track him down, they ultimately did a search of his bedroom. In his bedroom, they found ammunition consistent with the ammunition found at the location. They also found a small safe with psilocybin mushrooms, multiple items of drug paraphernalia, and trace amounts of THC. Because he lived in or lives in Walworth County, those charges were referred to the Walworth County District Attorney's Office. I see they have been charged. They don't appear to have been assigned an initial appearance yet, but they are now open pending charges, or will be soon pending charges in Walworth County. The law enforcement officers learned the following information: that during the course of this argument or incident, the defendant retrieved a firearm from the trunk of a car, displayed it, and then fired it at another human being. This created a disturbance at the Pine Cone restaurant. It actually led to that location having to be shut down from 12:50 in the morning until 7 a.m. the next morning. The agent did a nice job of not only recognizing the impact this probably had on the victim, or definitely had on the victim, but the collateral impacts this crime had, such as on this business and any patron who would use that business throughout the day or night, or those hours where it was closed. In the defendant's version of events, I think it's noteworthy now to reference the fact that, well, it might be new information to all of us that Mr. Odegaard is a felon. It's not new information to him. He was present in court when he was adjudicated as a felon back in 2019. He knows what that means. He was told what that means. Despite that, he's chosen to get a firearm and have a firearm and maintain a firearm and maintain ammunition for a firearm, and then carry that firearm around with him as he wishes. I think on a prior homicide case I did years ago, there was a comment that came up and it said, if you carry around a gun like chapstick, chances are you're going to use it. And here we have this young man earlier in this night on June 16th, drinking alcohol. He admits to drinking Tito's and lemonade, consuming or smoking weed with other people, bringing a gun with him while drinking and using drugs because he wanted to shoot it off in a rural area for fun. So it's not even a legal or a proper way to be handling a firearm in our community. And it's clear, alcohol, drugs, and firearms don't mix. The defendant then finds himself after this graduation party at the Pine Cone, where he gets into this verbal exchange with two young women, one of whom was 17 years of age at the time. That was the first girl that he was interacting with. It was the victim's girlfriend. You've heard from the victim today. It was her girlfriend that he was initially having comments back and forth with, and then it transitioned into back and forth with the victim herself.
So I don't know why I failed to track this, and sure it's me and not anybody else, but so it was a happenstance encounter.
No, they had been together for a period of time, and then I think it went outside into the parking lot. They were going to get food at the Pine Cone restaurant. They were waiting too long. They end up in the parking lot. There's continuing to be some contact and communication with each other in the parking lot.
Okay.
And then the defendant is starting to, I think, initially hit on the victim's girlfriend. Then it becomes everybody's knowledge, the victim and her girlfriend are not into men. And so now it transitions into some commentary between the defendant and the victim about their relationship.
Understood. Thank you.
In the defendant's version, he says it was the victim who was yelling at him, calling him names and starting to get aggressive by pushing at him, that he started to get mad and call her names in response, including some derogatory names regarding her sexuality. The defendant, in his own version, I think this is probably one of the most honest statements throughout this PSI that I see attributed to him, is very clearly he says he got really mad and he wanted revenge. And so he is already telling his friend at this point, this is in the bottom of page 4, that he was going to shoot off a round just to scare them. So there's some pre-planning in this too. It's not just this moment of all of a sudden he just grabs a firearm and bang, it goes off. No, he was thinking about wanting to get that firearm to shoot off a round to scare these other individuals. And as he's getting ready to leave, he does make this decision that he's going to leave. I think within the facts of the police reports, the victim kind of makes a comment to him like, bye. But the way she says it is mocking, like, bye. And that's what sets him off. He goes to the vehicle. He pops the trunk where the gun was being stored. He pulls it out. He has to load it.
Do you think she called him Felicia?
He puts one ammunition or one bullet in the chamber. He then had to walk back in the direction of the 4 people that he was with. And when he's about 25 feet away, this is when he chooses to point the firearm directly at the victim. He then lowered the firearm and pulled the trigger. And it shot right into the ground near her feet. When law enforcement were arriving on scene collecting evidence, they had the parties stand where they were standing. They evaluated the scene. And it was clear in law enforcement's review of the site that the bullet had hit the ground just a short distance in front of where the victim had been standing. The defendant then put the gun back into the trunk and sped off. I'm going to come back to this again a little bit later, but there are some comments about how much other people were influencing Mr. Odegaard's behavior this night. There's suggestions that, well, it's his peers or it's his friends or that it was the girl who was egging him on. The victim is more at fault here. But that disregards choice. There is influence and there is choice. And other people can influence your behavior, but you still have to choose the actions that you take. And in this case, if I just went back 5 minutes ago into my presentation, all of the choices that Mr. Odegaard had to make here, walking to his car, opening the trunk, arming himself with a firearm, loading the firearm, returning to the scene, pointing a firearm, discharging that firearm. And then the choice to get in the vehicle, the choice to flee the scene, and the choice to later dispose of that weapon. The defendant, as part of his statement, also says he felt a lot of guilt and regret, and that he knew he made a mistake out of anger. And again, there's that term. This was anger. The other mistake he made that night was not to turn himself in. If he was feeling guilt, if he was feeling remorse, he should have cooperated with law enforcement. He should have made himself available. They shouldn't have had to come and find him. And he most certainly should not have tampered with the evidence and destroyed it or discarded it or got rid of it. To this day, we don't know where that firearm is. And that's concern. That firearm is somewhere in our community, and who knows who could get their hands on it. And I think that's a problem. As to the victim's statement, many of the things that are set forth in this PSI were reiterated by the victim today, that she feared for her life, as she should have. She had a gun pointed at her and then fired at her. The collateral consequences that she's experienced as a result of this beyond her fear is not going to the Pine Cone, losing out on the 4th of July, losing out on the relationship with the girl she was dating on that night, losing out with her job, having a hard time finding yet another job. Earlier today, when we were talking about continuing this hearing, she referenced again the fear of potentially losing yet another job if we were going to continue this hearing to another date, just because she wants to be here to see this case through. And that was a potential consequence. Well, this can't be attributed to the defendant directly. I think it's noteworthy that individuals who were here supporting the defendant called the victim a liar when she was present in court. That's a further victimization of this woman. It's not by Mr. Odegaard himself, but it's by the very people he surrounds himself with. And it's the people he would be relying upon to help him when he gets back out in our community. And these are the people that are further aiding to the victimization of this individual. Beyond the impact on the victim, I've already commented on the impact, the likely impact on the business at Pine Cone, and the impact on our community as a whole. I mean, Johnson Creek's a fairly quiet area, and we have someone who's pulling out a gun and shooting it at a really common, well-established location. That this doesn't happen in Jefferson. It doesn't happen in Jefferson. It shouldn't happen. We then have the defendant's prior record. It's true, the only prior criminal conviction he has as an adult is this hit and run that is listed. He does have the juvenile adjudication that I referred to. I would note he's had a number of citations, traffic citations over the years, operating without a license a couple times, operating without insurance, speeding again, resisting, obstructing an officer again. The defendant now has several other open charges pending in Walworth County. He will soon have the charges related to the search on his house, the controlled substances, THC, and paraphernalia. He has an open case that includes 5 felony counts of second-degree sexual assault of a child as a Class C felony. He has 5 counts of Class C child exploitation. He has 3 counts of Class D possession of child pornography. He has 3 counts of felony bail jumping that were charged out after that other case, or charged out while this case was pending in a separate Walworth case. He has another Walworth case for felony bail jumping. And I see yet another second-degree sexual assault of a child matter still under review for further consideration for charging. So these aren't convictions. The court may not give them very much weight at all. I just point out that we have a fairly young man here with already a serious record between his historical conviction and the one before this court, but a lot going on in his young life, which certainly speaks to his character. One of the things he was asked about was that prior hit and run conviction that he had as an adult. I pulled up that criminal complaint. It's public record. I just wanted to see whether or not it matched up to his version of events. He said he was leaving the busy parking lot at work when he hit or scratched another vehicle. It's my take on this complaint, Your Honor, but I think he minimizes the offense of that particular hit and run. The victim was stopped at a stop sign when the defendant pulled up next to her and sideswiped her car. The victim in that case gestured at him, and the defendant acknowledged she was gesturing at him and drove home. Law enforcement would catch up with him later. That was the facts of the hit and run case, as taken directly from the criminal complaint. He then referenced that prior child sexual assault conviction that he had on page 8. And his comment on it is he didn't know it was wrong to have sex with someone that was of non-consenting age, since he was also a minor. I did check their ages. They were close, 1 year apart. He had a date of birth of 2005. The victim in that, or 2004, the victim's date of birth was 2005. So they were close in age. But nonetheless, the nature of that conviction certainly suggests something more substantial. when I see the family's information or input as to this case, it's not surprising to see families be supportive of a loved one. I don't take issue with the fact that families are supportive of a loved one, and that they would hope that the court would consider whether or not the outcome should be prison. I would note, though, that in reviewing the family statements regarding the offense, there is this kind of idea that, well, at the bottom of page 9, he was being pushed around and his friend told him to fire a gun. There was no ill intent. Well, that just contradicts the defendant's own statement that he was acting out of anger and out of revenge. There was another comment in there, is that the defendant must have felt really, really threatened to have gotten to the point that he felt that he needed to fire a firearm at this other person. And again, we just know that wasn't the case. He was already pre-planning it before he had even gone to the car. And so, while perception may lead some parties to believe that a lesser sentence is warranted here, perception is not reality. As to the remainder of the PSI, I think it addresses all of the concerns for the court. I think it addresses some of the factors that should be considered going forward, including Mr. Odegaard's lack of an education, a GED, and I think the agent touched upon why that's not only important to Mr. Odegaard, but I think a good thing for established. So when we get to the conditions of whatever sentence this court hands down, I think having a condition that includes encouraging him to get his high school equivalent GED or other education is important.
For no reason, I'm going to say I would buy Linus's poems.
I think we see some comments on page 17, again, quoted by Mr. Odegaard, saying he's always felt disrespected in life, always felt he had a target on his back. And maybe that explains why, when he's getting into this verbal argument with someone, he did go to the extreme in his response. I think it's important that he does acknowledge that someone could have gotten hurt or killed. That's an important recognition on his part, because it's absolutely accurate. I wish he hadn't followed it up in the same sentence by saying, well, my friend is a bad influence. I think that minimizes, though, his choice in this matter, not the influence of someone else. We see alcohol consumption not only on the night in question. We see reference to him consuming alcohol. We see him regularly using a gram of marijuana a day. So AODA conditions to address those high treatment needs is also something I'm asking the court to consider. So we get to the point now what the recommendation is for the sentencing outcome, the recommendation.
She has a lot of words, and she's sitting there saying everything, but she's just skipping pages. And in her documents, she's just like skipping. I don't even know what she's doing with those papers. It's very distracting.
Here by the agent was a prison term of 6 to 8 years. That would be 3 to 4 years of.
And now she stops. Thanks. Make me a liar. Thank you.
Confinement, followed by 3 to 4 years of extended supervision. This is set forth on page 24 of document 43. And my recommendation's higher than that. My recommendation is for a 10-year prison term. I'm asking for the court to impose the first 6 years to be served in initial confinement, with the remaining 4 years on extended supervision. Again, I think the PSI was informative. It was well written. It was spot on for the information that was known. There is that one omission, and it's a big one, and that is the fact that the defendant was a felon on the date of violation and should not have had. He was not permitted by law to have any sort of firearm, and he can frankly still face charges for that particular portion of this offense. And I think considering that and all of the other aggravated factors I've pointed out today, it does warrant a higher amount of initial confinement here, and that is why I'm asking for a 10-year sentence, 6 in, 4 out. As to the conditions of supervision also set forth on page 24, I agree with all 6 recommended by the agent. I would additionally add the following. I think the defendant should have to undergo random drug screening. I think he should, in addition to being absolutely sober, not be present in any bars, liquor stores, or taverns. I think he should be not allowed to possess or use any THC analogs such as CBD, hemp, or Delta H. And last but not least, I believe he absolutely needs anger management counseling. And I would ask those.
That was last? That one was the last one?
Conditions be added to the recommendation here. When it comes to the conclusion of this hearing, Your Honor, the parties have conferred on jail credit. We do have a stipulation and we'll provide that at the end of the hearing. Thank you.
I like how passionate she was the whole time. That's what we need in prosecutors.
Thank you. Attorney Toiber. Attorney Dade.
Thank you, Judge. As we talk about this incident that happened at the Pine Cone, Ms. Toiber has painted the picture against Mr. Odegaard very well, and there is no excuse for that behavior. It wasn't self-defense. And I think if you read the PSI fairly, you can see that Mr. Odegaard is not blaming anybody but himself. He is saying he has made some bad choices in friends, but he's not he's not blaming his friends for Mr. Odegaard's conduct. And one thing I note about the pre-sentence writer's contact with Mr. Odegaard is that he wasn't trying to shirk his responsibilities. He wasn't trying to explain away what happened. He was just, when they're asking him his version of what happened, he's going to give it from his eyes, but he never blames anybody else. And he knows that he's the person that made the mistake. And he honestly revealed an offense that nobody else would have known about for today. And I just want to talk about that offense. I don't have the facts in front of me, but I heard Ms. Toiber say it's 19 JV 10. And Mr. Odegaard was born in 2004, which would have made him 15 years old. And I heard Ms. Toiber say the person with whom Mr. Odegaard had sex or sexual contact with was 1 year younger than him. And Mr. Odegaard said he didn't know it was illegal for kids basically the same age. He didn't think it would be a crime for them to have sex because that's what a 14 or 15-year-old might think. And then Ms. Toiber says he knows he's a felon. That may not be true, that a 15-year-old kid who had a 14-year-old boyfriend ends up in trouble in juvenile court. And then when he's 21 years old, he may not know he's a felon and can't have a firearm. I know there are warnings and admonitions that come out of courts like this one when people are convicted of felonies. I don't know what happened in the juvenile court, but I don't think that he was trying to, that there's any indication that he knew he was a felon other than the fact that this record shows that he was convicted.
And in front of a judge and told to his face.
Of a B felony back in.
You have proof right there that he knew he was a felon. You have proof right there. There's a huge court document right there saying that he was found guilty.
2019, 7 years ago. If the court looks fairly at the compass factors that start on page 16, almost all of the compass factors show Mr. Odegaard as not being dangerous. I don't know how you square some of these things. On one hand, it says that his anger is not a problem, but clearly, in this case, his anger was a problem. And I don't dispute Ms. Toiber's suggestion or her recommendation that Mr. Odegaard should get anger management treatment, because if he hadn't got gotten angry and acted out in this case, then this crime would not have occurred. But let's talk about the crime, or let me talk about crime, the crime that occurred. Here's what didn't happen. Nobody got hurt, physically hurt. Nobody was shot with the weapon. And Mr. Odegaard, he loaded the weapon, took it out, pointed it in the direction of that person.
Oh, I get it now. I get it. He must secretly work for the prosecutor. It's the only thing that makes sense in his defense of his client. He secretly works right for the prosecutor. That's how they roll in Wisconsin.
And Mr. Odegaard said he didn't point it directly at that person. And even the other witness that was right with the victim said he pointed it in our direction. Well, I'm not trying to split that hair. It's bad enough. If he points a gun in my direction, I'm going to be traumatized. That's for sure. And he shot one time.
Just so you know, I didn't internalize it so much at all yet when I got to this point. And then he said that. Then he's like, well, if he points that gun in my direction, I'm really... And then I felt that, and I thought, oh my God, if he pointed that gun at me, I would be really scared. So he nailed it home for me how scary this would be. Hold on, are you really a lawyer? Hi, super lawyer. I'm just stopping at super lawyer. You need to go pro se. I love your advice. I agree.
Got into the ground. And then Mr. Odegaard said he realizes when his anger took him that far and he pulled the trigger and that weapon discharged, he realized he had made a big mistake. And he took the weapon, put it in his car, and got the heck out of there. People were afraid of him anyway. He was apprehended later that same night. I mean, midnight passed between between the discharge of the weapon and Mr. Odegaard being apprehended. But it wasn't like he was a fugitive from justice for a week at a time and got a great distance away from law enforcement people pursuing him. He was caught pretty much immediately. During this incident, he didn't make any threatening statements to anybody. He didn't say, I'll get a gun and kill you. I will shoot you. I will hurt you badly. He didn't say anything like that. So, and what he said is that he had no thought of creating a danger of injury, that he was just trying to scare people. Now, the way that he did it is criminal, is against the law, for which he has been convicted. And with regard to that conviction, he allowed himself to be convicted within 6 months of this incident. So he didn't drag out proceedings. We don't have a trial that had to be conducted. He accepted responsibility for the conduct he was charged with. And here we are today for him to be held accountable for it. A couple of other, and again, he fully cooperated with the PSI writer, which she writes in the PSI, that he was fully cooperative, answered all the questions, was truthful, candid, didn't lie, told his truth to her. the PSI indicates that he is statutorily eligible for challenge incarceration program and the earned release program. And if the court sentences Mr. Odegaard to prison, then I ask that the court make him eligible for those two programs. I'm not going to say anything contrary to the character of the victim here and the victim's conduct, because it's not relevant. People can be angry about a lot of different things, and you don't act out as Mr.
Super Lawyer, do you know where Jefferson County is in Wisconsin? North, south, east, west? Because the accents here are very light. So I'm guessing it's southern Wisconsin.
Odegaard did. But strike that, I guess.
He's just taking a little nap, guys. Just give him a second.
The court is directed by the bench book, Special Materials 34, and the Galleon factors, to impose a sentence with the least amount of confinement necessary. And Ms. Toiber has asked for more confinement than the pre-sentence recommends. On the basis of this record of a felony conviction between a 14 and 15-year-old kid from 6-7 years ago, we don't really have that file in front of us. We don't have the information. We can't read a criminal complaint like we could in the hit and run. And I ask that the court not use that part of Mr. Odegaard's record, which he revealed to the pre-sentence writer, as a means of imposing upon him additional time of confinement. I would ask that the court consider Oh, I know what I was going to say. My mind blanked out for a second when I said I'm not going to say anything negative about the victim here, but I do want to say that in the confrontation between Mr. Odegaard and her, according to his version, and nobody contradicts it, he was receding the whole time until he went and got the gun and did that wrong thing. He was not the aggressor. He never physically did anything to the victim, which isn't true the other way. And I want to point out that Mr. Odegaard weighs 120 pounds. That doesn't mean that people that are of small stature get a pass on committing felony crimes. But I just want to point that out, that he is a small person. In fact, that night he was being called a twig. Getting back to my recommendation on behalf of Dominic, that if the court can impose and stay a lengthy prison sentence and then stay it for lengthy probation, I think that's the appropriate sentence here. He doesn't actually need to go to prison, but if he screws up on probation, then he needs to go. I guess he gave up. He ruined his one chance to avoid prison. And if the court were to impose upon him 1 year of jail as a condition of,
And that doesn't mean anything. That's not like a weird word that Americans say. They mean twig, a little tiny little branch.
that probation, that year of jail could be could be more suffering, could be a loss of freedom more profound than 2 or 3 years of prison. And if the court can impose a lengthy prison sentence,
Now I get it. Not only does he work for the state, he's high as a kite. I don't understand his reasoning.
stay it for probation, conditions of probation could include lengthy jail and the conditions which Ms. Teuber is asking the court for, whatever sort of supervision follows Mr. Odegaard's confinement. We claim for 3 days jail sentence credit. Thank you, Your Honor.
Thank you, Attorney Dade. Mr. Odegaard, you have the right to say something before the court pronounces sentence. You're not required to. If you don't want to, I won't hold it against you, but it is your right. And most certainly, if you have something you want to say, I want to hear it. Is there anything you'd like to say?
Oh, Your Honor.
Okay. I'll start the way I often start in cases involving serious allegations and serious convictions. Mr. Odegaard, in pronouncing sentence here, the court has to consider the gravity of the offense. The court has to consider your character from a criminal justice standpoint. We have a substantial record about that. The court has to consider the need to protect the public. The court has to consider your rehabilitative needs. Attorney Dade made reference to special materials in the Galleon case. And very basically, well, I referred to the sentencing goals or the factors that the court has to consider, but Attorney Dade is correct. If the court's going to rely on initial confinement to advance or give due reflection or regard to any of the sentencing goals or factors, then the court has to use the minimum when it comes to that confinement. The court's required to start out with probation and stop with probation. I will say out of hand, this is not a probation case. It just is not. It would be grossly incongruent with your behavior, with the impact to the victim, with the dangers that were presented by your impulsivity and your choice that night. That distinction that Attorney Teuber, I have never heard it delivered that way. This is a distinction to be made between influence and choice. That's very important. It's so let me start out with the gravity of the offense. And Attorney Dade, he said, well, look, Judge, nobody was hurt. Nobody was physically hurt, but the charge here, the conviction, is designed to criminalize, control behavior that could hurt somebody. And your behavior most certainly could have hurt somebody. I've heard about the conditions here. This is a travel plaza that's open all or most hours of the day. I'm not a ballistics expert, but I think I can have a sort of a bland or generic impression or take away that round that hit the asphalt could have ricocheted into somebody, into the victim, into the restaurants, onto the interstates. We're at a place where there's fuel everywhere.
Chlamydia.
You combine physics and gravity and conditions and the specific round and how you're pointing it, and you combine all those things in that split instant. Nobody knows where that round's going to do and what it's going to do to somebody. So I understand. I can I I recognize that nobody was hurt physically. But again, this is something that the court has, there's a high and there's a high need to deter this behavior, generally and specifically, just given the distinct danger that was presented at that moment. And we hear about and we read about these things. It seems like very often. So when somebody says, well, I feared for my life when there was a firearm pointed at me, and you just think about that for just a little bit longer than 2 or 3 or 4 seconds before moving on to the next thing, and really put yourself or just think about or reflect on the idea of having a firearm pointed at you, even briefly. I traumatized is, I think that's a fair and appropriate and expected result. So there's an impact to the victim, well, certainly in that respect. And then these other impacts have been described. I'm mentioning these things again because I think the court has to consider these things. The court has to consider the impact to the victim, most certainly. I guess what you'd say, the lodestar here for the court sentence, the priority here, Mr. Odegaard, is deterrence through punishment, deterrence through confinement, deterrence, deterrence and punishment. And again, the court has to impose a sentence that's consistent with the gravity of your choice. The rehabilitation for such a young man, and I'm only calling attention to your youth because you're going to leave a confined and controlled setting as still a very young man, and it would be irresponsible, undesirable for you to come out of that confined setting and not have an even more appreciable period of time where you're closely monitored, closely controlled, so you can, so you're supported in intense ways in getting reintegrated. So I am considering your rehabilitative needs. I'm going to account for those. But this impulsivity, I think that word occurred, or some variation of it occurred 9 or 10 times in the report. That is, in a way, that's what needs to be attacked or challenged very intensely. And you're not going to be, and the court's not going to be more punitive with you when I tell you this, when I refer to this, Mr. Odegaard, but I am worried. I thought Attorney Toiber sort of alluded to this. I'm worried that you are surrounded by some enablers. I'm even more worried that some of those enablers might be people who very much love you too and care about you. And I get that. I get the
I'm an enabler to my children. Absolutely. I hate it. I hate it. That's what we need to learn in school. How to not be an enabler to your children. Because look around. Look around at where it got us.
natural inclination to do something, to say things that are going to avert an uncomfortable result for you. I get that, but no, Mr. Odegaard, now you're 21. You're not a child anymore, and this court doesn't intend to treat you like a child, especially under these sorts of circumstances. There's going to be sort of a hard stop here, because I'm going to say the court's going to use a prison system sentence here. The court believes that that's necessary for treatment. The court does believe treatment in a confined and controlled setting is necessary. it's also necessary to avoid a situation where we're unduly depreciating the gravity of the offense. The court is firmly convinced of these things. I think there are significant treatment needs here that can't be met in the community.
Happy birthday! Guys, it's Bren's birthday. Are you 50 yet? Did you turn 50 today? Because that's a big birthday.
That would be a worrisome proposition at this point, based upon what I've heard in terms of your. And I'm not talking about teenagers having sex with each other, and I'm not diminishing the criminality that goes with that, but I'm talking about this these other challenges that seem to persist in some level of adaptation that the community wants you to have at this point, Mr. Odegaard. And I guess I'm really coming back to that impulsivity. And, you know, impulsivity for certain people, I mean, it means different things for different people.
Okay,
For you on this
I don't think he hit 50 yet. He's a young'un. He's a little baby.
specific day, it resulted in a really scary situation that could have resulted in a real tragedy where you're sitting in that location, you're convicted of something far more that results in far more exposure. So we have to, this court believes the system, not just the court, but the system has to react to this in a way that's just not, Mr. Odegaard, we're just going to tend to your rehabilitative needs. Go make an appointment with your agent, and we'll talk again in 6 months or 12 months, or maybe you'll be successful and you'll never have an interaction with the court system again. That the court doesn't believe it.
Wait.
That.
So is it the 17th there right now? Are your birthday's on St. Patrick's Day, or is it still the 16th? No, it's the 17th now, right? Your birthday is on St. Patrick's Day. That's crazy. My sister's birthday is on St. Patrick's Day. But that's crazy. I hope you drink a lot today. A lot.
It's consistent with advancing the Gallian factors, and so that's not going to be the result. And the question is, again, getting back to minimums, what's necessary here to advance those goals?
You can still drink.
I want you to understand, Mr. Odegaard, that
I start drinking for St. Patrick's Day in November. So you can drink a lot today to celebrate tomorrow. Or I guess you can celebrate your birthday too, I guess, if you want. 47. Oh, man. I bet you have aches. They're just about to get worse.
I'm thoroughly considering that. It's not, routing a 21-year-old to the prison system.
I will drink for you.
We get to that result only in the face of something as significant as this, is potentially as dangerous as this, Mr. Odegaard. And so I am considering your rehabilitative needs. I think those are going to be furthered with the initial confinement portion of a prison system sentence, as well as the extended supervision. I'm going to add the conditions requested by the state. Those are fair, they're appropriate, they're supportive of what your needs appear to be. Your character, there was a substantial record made about that. It could be, and perhaps one might say it should be, but it's not of particularly significant impact here. So, Mr. Odegaard, the court's going to sentence you to 8 years in the Wisconsin prison system to be served as follows: 4 years initial confinement, 4 years extended supervision. The conditions of extended supervision are as recommended and indicated on the PSI report. And so I'm looking at page 24 of 26. They are as follows: cooperate with any treatment, counseling, deemed appropriate by the agent, complete AODA treatment, maintain absolute sobriety, no contact with the victim or the Pinecone restaurant, get a GED or full-time employment. Does that somehow vary from what you were suggesting, Attorney Toiber?
No, Your Honor.
Provide a DNA sample.
Yes, it was, Your Honor. That's 1 year less than what she asked for in probation, sir.
Anger management counseling. As per the agent, the anger management counseling that's not a discretionary thing for the agent. What is discretionary for the agent is what sort of resource or program will amount to fulfilling that particular requirement. Random drug and or alcohol screening, no presence in bars, taverns or liquor stores. Give that THC analog language to me one more time, Attorney Toiber.
The way I phrased that was not to possess any THC analogs to include CBD, hemp, Delta 8, or other similar products.
Okay, that is as well a condition of extended supervision. Did you say 3 days, Attorney Dade?
Yes, Your Honor.
3 days credit is Attorney Toiber.
That is correct.
He is eligible for both forms of programming. I'm saying that's the boxes. Those are the boxes I'm checking on the worksheet. I don't remember what the writer said.
It does say on the bottom of the cover of the PSI that he would be eligible for both challenged incarceration and substance abuse programming.
So he's eligible for both forms of programming. Thank you, Madam Clerk. Mr. Odegaard, you're a convicted felon. You can't possess a firearm. If you do, you could be charged with another felony. If you're convicted of that felony, you could be sentenced to prison. You can't vote in any election in Wisconsin until your civil rights are fully restored. You have the right to appeal this case. Discuss that right with Attorney Dade. Go over the form that details the right and make sure you know what the deadline is. If that deadline comes and goes, it's pretty unforgiving.
No. That's good. That's enough of a punishment. He has to sit while that attorney goes through that whole form with him. Judge, lock me up.
It'll be difficult for you to appeal. Do you understand that, Mr. Odegaard?
Yes, Your Honor.
Anything else, Attorney Dade?
No.
I see guns
Attorney
in
Toiber.
the bar.
Nothing
all
further.
the time,
Thank you.
And Madam Clerk.
Constantly.
Mr. Odegaard is remanded to the custody of the Jefferson County Sheriff to give effect to the court's prison sentence. Recess.
Hi, Jude, love. Okay. In time, here we go.
And we'll start with you, 73D02 2603 CM136. You are Ryan C. Mann. Is that correct?
That's correct, sir.
You read, write, and understand the English language.
Yes,
What's the highest level of education you've obtained?
ninth grade.
All right. You have before you a charge of domestic battery. Have you read it?
Yeah, yes, sir.
You understand it?
Yes.
You have any questions about it?
Um,
Domestic battery is punishable from 0 to a year in jail and 0 to a $5,000 fine. In addition, if you're convicted of domestic battery, you will lose the right to bear arms. Do you understand that?
yes, sir.
What's your date of birth?
12/15/1991.
What is a good address for you? Okay. Do you have a phone number?
No,
Do you have email you check on a regular basis?
no, sir.
Do you work?
I do not work.
Why not?
Why should I?
What? What did he just say? Why should I? Is that what he just said? That's exactly what he just said. Send him to jail, Judge. Just put him in jail.
Well, I don't know. I suppose somebody puts food in your mouth and a tent over your head, or I don't know. How do you pay your bills? Or are you just lucky enough to have no bills and everybody else just loves you so much they want to pay for everything for you?
Sure, yeah.
Okay. All right.
Right, so do I have a no contact order?
Well, we haven't talked about that yet, so I'm gonna read the police report.
Okay,
All right, I found there's probable cause. Yes, I'm gonna grant the no contact order. You have no contact with Jennifer Sue Mann in person by telephone or letter through a third party or any other way, directly or indirectly, except in return of reckless in custody pending trial. This includes not limited to acts of harassment, stalking, intimidation, threats, and physical force of any kind. If you would violate this order, it'd be both a state and federal offense, and I could revoke your bond. Find your danger to the public and others out there. I'm gonna set bond the amount of $50,000, 10% cash allowed, cost you $5,000 to bond out. He's on probation. Is that what this is? Okay. On July. Yeah. All right. If you do bond out, I'm going to place you on electronic monitoring as well. So you will be under moderate supervision. You'll abide by all general conditions, report to court services as directed. You'll have at least 2 check-ins every month. Supervising officer, alternate report options may be utilized. You'll find special conditions pursuant to court order. Upon you'll remain in custody until they place a monitoring device upon your person. After placing the device, your posted bond will be allowed, and you will not possess, carry, use any firearm, destructive device, or dangerous weapon. You'll be on electronic monitoring and pay for all that. I found by clear and convincing evidence of supervision is necessary to ensure either your appearance in court or the physical safety of the community of another person. You have a prior unrelated conviction for any offense, and you have the financial ability to pay. Are you going to hire an attorney to represent you this day?
all right, I need a public defender, please.
So whoever's paying all your other bills not willing to pay for a lawyer for you? No?
He should not get a public defender. Look, this is America and everybody has right to counsel. They do. But if you just don't feel like working at all, then no, you should not get a free lawyer. You just shouldn't. What is he drinking? I don't think it's soda because the foam doesn't look right. Do you see his drink? It looks like he has like a crazy straw in it, but I don't think he does. I mean, it looks like coffee, but it's in a great big soda cup. But I don't think it's soda, cause look at the way the foam is. What is he drinking? Anybody? Cold brew? Maybe?
Are you going to answer my question, Mr. Mann?
I can't afford to hire anybody. I've been out of work for a while. I've quit smoking weed for 2 weeks now, and I started drinking a little bit to try to get a job, and now I'm here.
Well, I admire you for trying to give up the weed. That can be a hard thing to do, Ryan. I understand that, but trading one bad habit for another is not a real good solution. You understand that?
Yes.
All right. I'll appoint a public defender to represent you. I'll set the matter for a pretrial conference April 29th, April 29 at 8:30 a.m. Your bench trial will be April 30th at 1 o'clock. April 30th at 1 o'clock. You have any questions?
No, sir.
That'll conclude your hearing. Thank you.
Hold on, I'll find out what county if you give me 1 second to put another clip on.
There, there. Are you Joshua Foster?
Yes, sir. Well, yes, Judge.
Your home address, please?
In Indiana,
Your date of birth?
December 17th, 1994.
And how old are you now?
31.
Do you read, write, and understand the English language?
Yes, sir. Yes, Your Honor.
How far did you go in school?
11th grade.
Are you currently under the influence of any drugs or alcohol?
No, Your Honor.
Please listen while the state reads the charge and the possible penalties.
On or about March 5th, 2026, in LaPorte County, state of Indiana, one Joshua Foster did unlawfully, knowingly, or intentionally, or recklessly make unreasonable noise by screaming profanities when asked to stop, and continued to do so after being asked to stop. It is a Class B misdemeanor, punishable by up to 6 months imprisonment and up to a $1,000 fine.
Do you understand the charge and the possible penalties?
Yes, sir. Yes, Your Honor.
It'll be set at 305 cash with a surety option of 2,500. Do you expect to be posting bond?
I was gonna ask you if there's any chance I can get out on an OR because I don't have the money for bond, but I am looking, and I can get a lawyer and do everything by this situation correctly if I can get out and go talk to my lawyer and go back to work.
Yeah, I don't think that's gonna happen today. I'll bring you back in a week. If you're still there, we'll take another look at it.
Okay, can I is there any way I can make a phone call? Because I haven't been able to make a phone call since I got on here. If I can make a few phone calls, I might be able to pay bond. I just have to go make some phone calls.
We'll look into that for you.
Okay.
March 13th, 1:30.
All right.
So actually, I have one more thing. I have a court date on March 12th in Porter County, and I need to get a hold of somebody so I can do that too. You know what I mean? Because I have court in 7 days.
Your excuse.
Your excuse. He's
State of
in
Indiana
jail
versus
for,
Gary.
he's in jail for screaming profanities. Guys, I'm probably going to jail today. I have a high chance of going to jail every single day. Just so you know, if I'm not here tomorrow, I was abso-freaking-lutely screaming profanities. Maybe at a cat, maybe at a person, I don't know. Not my dog. Nobody swears at my dog. Let's go to Judge Fish. Oops. Who is, oh my gosh, Indiana.
Ready? Good afternoon. This is 64D052411PL 11879. Greg Schaefer versus M7 Excavating LLC. Tom's, how do you pronounce it? Zeph. Zeph. It's easy as it looks. Rick Moore and others. Looks like I have Mr. Schaefer in court in person and pro se. I have. You're not Mr. Sorden.
I'm Mr. Seville, Your Honor.
Yeah, Seville. There you go. In court for the defendants. We're set today on a 41E. Is that right?
Yes, Your
All right. How would you like to proceed?
Honor. Yes, Your Honor.
Your Honor, may I just, one question for the court?
Uh,
Well, it's in reference to sequence here.
okay.
Okay, on January 16th, Mr. Schwarden requested the court, if you will, to substitute counsel, which is Mr. Seville here, but I don't believe there's been any official ruling on that. And I'm just expecting the record obviously to be correct, that has been accepted, and Mr. Seville has a right to represent the parties that are at cause here. And the fact of the matter is, I don't believe there's been any ruling on that. Do you see that on January 15th, 2026? Notice of substitute of counsel is filed?
I do. Have you entered an appearance yet?
I have, Your Honor. It was included with our substitution counsel, I believe. Verify with my office that the fresh one gets submitted, if that would make it easy. I don't see it attached on the documents that I have.
Yeah, normally when I get them like that, the way the new rule's crafted, if you're with the same firm, it sort of suggests that you don't have to do an appearance, but I always order people to file an appearance anyway. So yeah, I'll order you to file your appearance, and I'll get back in there and grant the withdrawal for Sorden. Sure.
And that is a taste of the rest of it. The rest of this hearing is going to go right along those lines.
Again, Your Honor, I'm not challenging that. I'm just going to get the record straight that Mr. Seville now has, Mr. Schwarden has stepped away or has requested to step away. And in fact, Mr. Seville is here to take that position. But again, my filings have to be correct with the right parties and directed to the right counsel, and right now it stands that it should have went to Mr. Schwarden.
Yeah, I mean, that got caught up in Judge Tody sending the case back to circuit court. But in any event, I'll get back there and I'll get back in it and sign off on the withdrawal for Sworden. And then Mr. Seville can have a couple of days to get his appearance on file. Not a big deal. Okay. Yeah, you want to go ahead with your motion, sir?
Yeah, sure.
Thanks.
So the reason we filed a 41E, Your Honor, is just, again, 41E, just to remind everyone, is whenever there's a failure to comply with the rules, no action's been taken in a civil case for a period of 60 days. It can be ripe for 41E. We were looking at the filing history, Your Honor, and there had been a motion to compel back in April of 25, a motion to strike April 15th of 25. There was an order on the same, and then a dilatory response that came in May 12th after an order was already entered and was therefore of no consequence. After that May 12th, 2025, a new special judge was assigned as of June 10th, had accepted and taken over. From that June 10th date to at the time of our filing, January 14th, 2026, over 7 months later, there had been no filing, no action, nothing had been sent to the parties, nothing had occurred. And again, a complaint isn't a sort of Damocles that can sit forever. At some point, some action has to be taken. We decided, okay, we'll file a 41E based on the fact that this has gone over 7 months with no action of any kind. Then again, on March 6th, again in dilatory fashion, Mr. Schaefer filed a response nearly 2 months later. And then as of yesterday, Mr. Schaefer did submit discovery requests to my office. Those discovery requests, however, again, the idea being that the plaintiff should be advancing their case, should be prosecuting their case, and should be taking steps to move the case forward.
I love Chip and Dale.
These discovery requests don't appear to do that, Your Honor. And if I may, may I approach, Your Honor?
Sure. Thank you.
Your Honor, these are the requests that were submitted by the plaintiff in this matter yesterday. And again, the idea is that we should be prosecuting this case and moving it forward. And instead, these appear to be a rehash largely of issues that are already decided, or issues that are just really calculated to harass or annoy. We have everything from a request for Attorney Sorden's insurance information when he's not a party to the case, as interrogatory number 9. We have requests, again, and it goes on, requests for conflict checks for attorneys as though there was going to be disqualification of counsel. That request was further made in, I believe, in number 7. In number 6B, there was a request whether any attorney confirmed the water shutoff status, which is not, again, what attorneys are for. Request 5A requests 52 years of history of installing any blocking devices, and the list goes on. And again, this is not calculated to advance this case. It's calculated to harass and annoy. And this is something that was, again, filed extremely dilatory. Again, we're looking at this point, almost 10 months have gone by since the plaintiff took his last action in the matter. And the issue becomes, at a certain point, a lawsuit must either be progressed meaningfully or not. And there had been no actions taken. We filed our instant motion in January, expecting a response. The only response that was received in this matter, and I just want to go back to that response that was late filed on March 6th, and we look at his defenses. He states that there was discovery non-compliance. However, there was a sanction against Mr. Schaefer in this matter earlier because he had not complied with the 26F requirements at the time. He was supposed to try to handle matters outside. He did not. That's the only non-compliance that's been found in this matter, was his own. There was again, he said there was dispositive sanctions for striking discovery without fair process. The only response he provided was one that was several weeks late under local rule 3300. He says there was a case disruption caused by the court's later recusal and reassignment. However, as pointed out previously, there was a judge that was assigned June 10th, 2025. There was no action at all, and that judge remained in effect at January 14th, 2026, over 7 months later. And so his argument that somehow that recusal and reassignment caused a delay, there was no recusal or reassignment during that 7-month period, which is more than 3 times the requirement under the rules of 60 days. So based on those items and the dilatory fashion in which he's prosecuted the case with regards to a failure to handle his 26F matters, a failure to provide discovery, a failure to respond to the motion to strike in a timely fashion, a failure to respond to the existing 41E motion in a timely fashion, it speaks to continued dilatory actions. And Your Honor, I would state that this case is pretty much on all fours with Belcaster v. Miller, 785 Northeast 2nd, 1164, if I may approach.
Yeah, that's what I was looking for. It's got the 8-point checklist. Is that right? Okay.
In that case, very similar to this case, there was a 10-month delay by plaintiffs, multiple dilatory actions by the plaintiffs, and the court was upheld as having found that that warranted a failure to prosecute in the matter. And here we are almost exactly in the same timeline and same situation. We have multiple dilatory filings. We have a 10-month delay between April, when the last order was issued, and March now, where we're sitting today, and we've received our final response as of last week on March 6th. Given the conditions and the failure to prosecute the matter, we were asking the court to enter an order of dismissal pursuant to 41E. The plaintiff has provided in his answer no explanation for his dilatory filings or his failure to act during a more than 7-month window where everything was stable. He had a stable judge. And again, his answer provides no further explanation in his response for the dilatory nature of his prosecution of this matter. And the latest discovery he provides suggests it's not calculated to reasonably move the case forward either at this time, Your Honor.
Prejudice?
At this time, we believe there is prejudice, Your Honor, because as this case has progressed for over a year now, and we've suffered from a situation in which he's now requesting further discovery that appears to be designed to calculate to harass and annoy rather than to move the case forward. This is costing legal fees for the client, obviously, but it's also beyond that fact. It's going to cause prejudice with regards to people's memories, different board members getting assigned, because now we have a situation where, again, there's been an election, board members have changed out, and there's going to come up another election before too much longer. And as this is happening, it's going to cause corporate memory to fade. And as a result, as corporate memory starts to fade and these issues become more compounded, it's going to make it more and more difficult for us to properly defend the matter.
Okay. Anything else, counsel?
No, Your Honor. Thank you.
Okay, thank you. Mr. Schaefer?
Yes, sir. Yes, Your Honor. Really, I'm going to take my time to kind of really walk right through the case, if you will. So if there's something that's unclear, please bring to my attention and you can stop me. First of all, on November 18th, 2024, the original complaint was filed by me against the defendants, if you will. On December 16th, 2024, Attorney Schwarden enters an appearance for the SFU. That was one of my concerns that Mr. Seville was sitting here today. On December 16th, 2024, Mr. Schwarden is granted 30 days extended time to response, which is perfectly fine. December 27th, he answers the complaint. On January 14th, Schaefer files an answer to his counterclaim, if you will. On February 18th, 2025, Schaefer submits interrogatories to the defense. Now, this, of course, is not in the CCS interest because this is delivered directly to their office, just like yesterday's was also. On April 3rd, 2025, the defense counsel, if you will, is 50 days has passed and there was no response to the interrogatories. So Schaefer extends him an additional 7 days to respond. And of course, the trial rules, I believe, I'm not going to spit out the right numbers, but you have 30 days to respond with interrogatories, and 30 days had went by. In fact, 50 days went by, and that's when I sent my message out to Mr. Schwarden. And that was simply saying, hey, you've got, I'm sorry, did I interrupt you, Ron? Do you have a question? Oh, I thought you asked me a question. I'm sorry.
I didn't say anything, sir.
Oh, it might have been some coughing there. I'm sorry, Your Honor. But in any event, where I left off here for whatever, is that I sent out the interrogatories on the February 18th, and 50 days had went by, if you will, with no response. I extended Mr. Schwarden 7 more days to respond, or I was going to file a motion to compel, which he did not respond. So on April 11th, 2025, I filed my motion to compel. Now, on April 15th, just 4 days later, Mr. Schwarden, instead of simply responding as per the Indiana trial rules, Schwarden fabricates a story that there was a dispute within the interrogatories, files a motion with the court to strike Schaefer's interrogatories, and then requests sanctions against Schaefer for $800 for not complying with his demand of conference, giving Schaefer 2 time slots to confer. Seems a little unreasonable, but in any event, seems like that's a well-oiled motion he must file. But whereas really nothing needed to be, there was no conflict of interest at all involved. He never, and I'm confused. Under what authority does Schwarden think he is not required to answer those interrogatories? There's no mention, there's no delineation, and does not point out a single line within the interrogatories that requires a dispute conference and request to strike all interrogatories and further request attorney fees as damages for $800. Now, on April 22nd, 2025, just 7 days later, without having a hearing or giving Schaefer his 20 days to respond or to reply, the court grants the defendant's motion to strike and grants a $400 sanction fee against Schaefer. On May 12th, 2025, Schaefer files a response motion in opposition to the motion to strike and objection to the sanctions, motion to disqualify counsel, enforcement of the bylaws, and for a change of venue. Well, it's a pretty hot potato issue there. And further demonstrates that the court did not even give Schaefer an opportunity to respond, whereas her decision was made 7 days of the defense motion filing, and in spite of the trial rules that provides 20 days to respond, further, the court didn't even provide for a hearing before her decisions. Hence, Schaefer had never even stepped in the court as of yet. This was simply a one-sided decision on paper, and Schaefer's motion has yet to be ruled on. On May 21st, 2025, the judge recuses her jurisdiction just 9 days after Schaefer's motion filed on May 12th. On June 14th, the Honorable Judge Toti accepted.
I am sorry about the dinging. If you can hear the dinging, I am talking to you, that dinging. I'm talking to YouTube right now about the messages. So the dinging is going to continue. I'm sorry.
The special judge position. On January 14th, motion for default judgment is filed by the defense. Now, on January 15th, 2026, notice of substitution of counsel is filed. That was what I had brought up early. On January 16th, the Honorable Judge Toti recused himself from jurisdiction, whereas he was retiring. So right at that point in time, We don't even have a judge in charge here for whatever. And on February 4th, 2026, the Honorable Judge Fish accepts jurisdiction. Court ordering a hearing for today. Go on here. On March 6th, 2026, Schaefer files a response in opposition to defendant's motion to dismiss. Now, again, he's doing this without any interrogatories at all that he requested months earlier, and requested to set in his motion and a request to set conference and dispute schedule for today, along with exhibits, original interrogatories, which you do have a record of that, Your Honor. I've enclosed that as an exhibit, which were struck demonstrating Schaefer's opposition to strike the interrogatories. And on March 11th, 2026, sends both attorneys, Seville and Schwarden, a copy of new interrogatories. Now, again, this was done on March 11th, yesterday, as far as that goes. But the fact of the matter is I've had absolutely no opportunity to depose anybody. They won't even answer the interrogatories. When I do file a motion to compel, the judge turns a blind eye to my argument and just strictly strikes all the interrogatories. Maybe what might have been more appropriate is saying, well, Mr. Seville was cleverly calling out specific questions. Well, that's probably what should have done. He should have pulled out the areas of question and brought it to the court. But that's not what happened. What she does is she strikes my...
Yeah. They just asked me for a screenshot of the deleted messages. Yep. That just happened.
Entire motions down, which I would imagine is a little out of the ordinary, and then turns around and sanctions me for whatever. All that done, if you will, without giving Schaefer even a chance to respond. Now, that's reversible error, I think is the term they use on that. But on March 11th, like I say, I did produce additional interrogatories, which lets the case progress. Now I'm going to do a simple review here again. A simple review. Schaefer files his complaint in November of 2024. 7 months later, the judge recuses herself. Just after Schaefer files his motion objecting to striking the interrogatories and the sanctions of $400. He's going to have his word regardless of not. Section B is 390 days have expired since Schaefer attempted to proceed with interrogatories, and not a single piece of evidence or interrogatories have been tendered or requested. Now, on the third time in this case, there's a new judge appointed in this case, and that happened last February 2026. On April 25th, 2024, the board of directors hired an excavator to dig up my front yard 12 feet into the ground and to install a sewer plug at a cost of $2,600. With full knowledge, the water service had been turned off at that location for 3 years.
Are
Hence,
you talking about the case now?
yes, sir. Yes, sir. This is the M7X. The M7 is one of the,
You're talking about the complaint you filed?
yes, sir. Yes, sir. The actual complaint. Yes, sir. I guess it wasn't clear
You don't need to
enough.
get into that.
Pardon, sir?
You don't need to get into that today.
I'm not sure what you're asking me.
I didn't ask you anything. I gave you an instruction.
Oh, I'm sorry.
You don't need to get into that today. I don't need to know what this case is about today. You don't need to spend a lot of time on that.
Okay, I understand, sir. I
Okay.
understand, Your Honor. Okay, okay, well, the other part of it was that, the parties, if you will, that dug up my front yard, if you will, who are a part of the case, and Mr. Seville is representing them, if you will, they have created damage. And we're not going to argue that point of the case right now, but the point is they are asking for a dismissal. They're saying, I didn't move fast enough, where to the contrary, I have waited 390 days for the decision whether the court was proper in only responding with an answer to my strike of interrogatories, and only 9 days had 9 days later she recuses herself, and then Judge Tody comes on, he retires, and then Judge Fish comes on. So the fact of the matter is the thought that I am not trying to move forward couldn't be more further from the truth. Yet I am. There's actually 4 lawsuits that I'm involved in these cases for whatever, and schedules are being juggled. But the fact of the matter is I'm entitled to my day in court, and I think the record shows that on all conditions involved, that Schaefer did try to move the case forward, but Schwarden, who's not in the court today, maybe he should have been, wants to turn around and claim through Mr. Seville here that I didn't progress on the case. Well, we went through 3 judges and 390 days without interrogatories. What's one supposed to do? So in closing, I believe this is my 5th hearing concerning these lawsuits, all without an attorney, while taking off work, while these 3 directors and attorneys drain the SFU treasury of the SFU to fund frivolous lawsuits and indemnify themselves, but deny Schaefer's privilege for indemnification. I'm just about done here, Your Honor. So again, somebody remind me why we're even in court here today. Schaefer can expect anytime soon, can Schaefer expect anytime soon his motion to file on May 12th, which was captioned response brief in opposition to motion to strike and motion and the support of motion to compel, objections to sanctions, and motion to disqualify counsel, enforcement of bylaws, and request for change of venue. None of that has been ruled on. So I place motions in front of the court, and it evidently falls on deaf ears, and I'm certainly not referring to this court, Your Honor, because I know you just took position not long ago. But the fact of the matter is the reference is that it appears that when I file something, it maybe doesn't even get read, I'm not sure, but then we enter into court here again today, if you will, where I have filed a motion back on, I think it was March 6th, that lays it out, and I'm not sure any of that has been addressed yet. So I don't really have much more to answer, Your Honor, but I'm certainly entitled to my day in court, and I don't think there's anything that Mr. Seville said that would turn around and claim that this delay is mine. I want those interrogatories because the minute I get them, I know who I'm going to subpoena again, not subpoena, yes, take their depositions rather. And but without the interrogatories done, it is premature to even call for the depositions of the parties that need to be deposed. Laid out pretty well in my, I think, March 6th motion. I have nothing else. I guess you have a question for me, Your Honor.
No, I don't have any questions for you.
Boomer trivia. In the 70s, what was the scariest M&M?
I do have a ruling, though. Firstly, let me go through a couple of things with you. I want to make sure the record's clear on what happened with Judge Butendorf. She didn't strike your interrogatories or strike any requests for discovery you made. You filed a motion to compel responses to the discovery that you tendered to them originally. She struck your motion to compel. She struck your motion to compel because she was convinced that you didn't follow the Trial Rule 26F requirements to attempt an amicable resolution of the discovery dispute before you filed your motion to compel. That's what she ordered. Well, I don't need you to say anything. I just need you to digest that. I mean, process that for a minute. She struck the motion to compel. Any discovery vehicles you already had submitted to them were still out there. You just have to look at the trial rules and look at whatever other resources you use when you work on things like this and figure out what you need to do to be able to enforce discovery. But if you didn't engage in some kind of like discovery conference or a telephone call or something with Sorden, then you didn't satisfy 26F. I mean, 26F very clearly lays out that you've got to do something more than like email somebody, right? You can't just send them a note and say, hey, you have to respond to my discovery. There's more to it than that. Okay? So that's what happened with her.
May I respond to that, Your Honor?
No.
Okay.
There's no need to.
Okay.
And then the other thing that you've misstated is what happened regarding your May 12th, 2025 motion. Apparently, Judge Butendorf did read that, because as soon as you told her that she had to get out of the case, she got out of the case. And when you do that, she's not allowed to do anything else with the motions that you filed. So when I reviewed this case, I looked at the pending motions. I didn't go back far enough to see that this was still pending. And I do owe you a ruling on what you filed back on May 12th of 2025, from what I can see here. One thing that happened at the beginning of this hearing was that there was the presentation to me of the discovery responses or the discovery requests that you just made a couple days ago to the defendants in this case. And there's this suggestion that they don't move the case forward, and they're presented here in this motion today. But I think that's the improper place to do that as well. The trial rules control discovery, and I don't like to be involved. And I was also going to talk to you, Mr. Schaefer, about how you filed your discovery responses with the court. And I was going to give you a little bit of a
Red. They got rid of red M&Ms because they thought it caused cancer, but it wasn't the same red dye they used in the red M&Ms. They just got rid of it because all Americans were scared of red dye.
talking to, but it looks like when you
Came back in the 80s, though.
filed those, you mean to support your response of May 6th related to this motion to dismiss, to show that you had filed those. Normally, you don't file discovery with the court. And I was going to holler at you a little bit about, I think it's Trial Rule 5 and the prohibition on filing that stuff with the court. But in any event, the 41E is a nuclear option. You understand that? A nuclear option where a case gets dismissed for lack of prosecution, for want of prosecution. And I have to look at these. There's only 9 factors here. I thought there's other cases that maybe had 8. Maybe I saw one that had 10. Length of the delay here. Length of the delay in a case like this, with all the change of judge, with all the uncertainty about where the court's going to be, I don't think is significant. That weighs in the favor of the plaintiff. The reason for the delay, I think there's, again, some confusion, and it's combined with number 3, the degree of personal responsibility on part of the plaintiff. And then number 4, the degree to which plaintiff will be charged for the acts of his attorney. Well, he's acting pro se here, so he's responsible for the whole thing. The reason for the delay is, I think, primarily a misunderstanding of what occurred related to the motion to compel. And now there's a misunderstanding about how to move discovery forward. Because a few minutes ago, you said you don't think you can take a deposition until you have interrogatories back. And that's not true either. You take a deposition whenever you want. All right. 5 is the amount of prejudice to the defendant. I don't think the prejudice is significant here. That also weighs into the favor of the plaintiff. Presence or absence of a lengthy history of having deliberately proceeded in a dilatory fashion. I know Mr. Seville tried to present an argument that you've proceeded in a dilatory fashion. I don't know that limited competence and dilatory are the same thing, but you certainly should pay closer attention to whatever resources you're using to present this case, because I don't think that you've given them a full review and have put your best foot forward on how to accomplish what you're trying to accomplish under the trial rules. Number 7 is where courts have to defer to process. The existence and effectiveness of sanctions less drastic than dismissal. This is a nuclear option, 41E. I need to look at things that aren't so significant, and none of those have been relied on in this case. There's been no case management whatsoever. As Mr. Schaefer noted, there have been motions that were pending that were not ruled upon. And the desirability of deciding the case on the merits, I know you got into that a little bit and I shut you down. There's always a desirability to decide the case on the merits, and we're not past that in this case as well. Number 9, the extent to which you've been stirred to action by the threat of dismissal. you certainly were motivated to get some new discovery over to the defendants here. And there's a counterclaim pending as well, and the court doesn't, the court understands that that's important as well. So I'll deny the motion to dismiss under 41E. I will get a case management calendar going on this case. I think it's important for us to do that. Oftentimes when you have two lawyers involved in a case, that's the result of a motion for 41E, especially when it's one that's only on a case where there's been a warrant of prosecution for about 10 months and there are discovery requests in the kitty, so to speak. They call each other on the phone, and then there's a resolution that pushes the case to case management. There's a resolution that pushes the case to mediation, discovery, things of that nature. So what I'm going to do, Mr. Schaefer, is give you 30 days.
Did you say 4-0, Your Honor?
Sorry?
Did you say 4-0 or 30 days?
I'm going to give you 30 days to figure out how to prosecute a motion to compel. So 30 days to enforce discovery. Then I want to set this case for case management. My summer is really difficult. In this case management conference needs to be in person because of the pro se. I usually do them on Monday afternoons and Friday afternoons. Are you local, Mr. Seville?
Yes, Your Honor.
Like Valpo local or like?
Not quite close enough.
Okay. I just don't like to keep a guy until 4:30 on a Friday afternoon if he's got to drive back to Indianapolis. But I have time on August 10th, which is a Monday. Let's have you guys in at 3 o'clock on August 10th. That'll be in person here. Only 15 minutes reserved. Discovery conference, not a discovery conference, but a case management conference. What you want to come prepared to do is to tell me how far you've come along with your discovery since the last time we got together. And if you want to get to mediation, then have an idea who you want to have mediate the case. Have an idea about how much time you need to complete your remaining discovery. If you're having problems with discovery, you can talk about that. But my assumption is that you're going to get whatever you need to get on file after you try to resolve your discovery dispute with Mr. Seville as the rules require. And then I'll order Mr. Seville to get his appearance on file. 5 days. And I have a note to myself, I've got a rule on those other motions. And I think with that, we can be adjourned.
Thank you, Your Honor.
Thank you.
I'm not stopping the stream yet because I'm fighting with YouTube right now. I'm asking for a manager. I am. I asked her if she could just let me speak to someone who forget it. I won't say what I said. All right. We're going to Georgia. Just because I want to get this out of the way. We have been following these RICO cases in Georgia where they're bringing guns and drugs and all this stuff into the prisons in Georgia. Nothing crazy happens here, but we get to see, finally, after years, one of them sentenced.
His attorney, Mr. Maxwell. I have been handed up a plea sheet here, so you have a negotiated plea. Is that correct, Mr. Maxwell? All right, and Ms. Stanley, present the terms of the recommendation to me.
It will be count 1, 5 years to serve, credit for time served from 12/14/23 to 12/19/23, and 8/5/25 to 3/3/26 for a total of 216 days. he would have 4 years and 149 days to serve suspended, which would be lifted upon any violation of probation. He would have the standard drug and alcohol conditions, Fourth Amendment waiver, banned from DOC properties unless serving as an inmate and no contact with any co-defendant named in the indictment. Count 16 would be 5 years probation, which would be consecutive to count 1, a $700 fine, drug and alcohol conditions, Fourth Amendment waiver, banned from DOC properties unless serving as an inmate and no contact with any co-defendants. That would be a total of 10 years with 5 years to serve, but the suspended amount of time to serve.
Got it. All right, Mr. Maxwell, anything to add to that? Now, Mr. Owens, that was a very complicated recommendation. I know you've gone over it with Mr. Maxwell, and I'm going to have a lot of questions for you in just a moment to make sure that you do understand all the details. But before we go diving off into the weeds, so far, has everyone said what you expected them to say? Like I told you just a moment ago.
Now, this is Mr. Maxwell, and none of the ladies that we have been following up, but they didn't come up yet. Only he did.
So before I can get to the disposition phase of your case, I have to first go through a process with you where I ask you a series of questions to make sure that you understand all the details of this plea, but just as important that you understand all of the rights that you'll be giving up if you complete this plea agreement today. If at any point during this process you don't understand my questions or you need more time to talk to your attorney, just let me know and I'll give you all the time that you need within reason. Do you understand everything so far? Is this your free and voluntary plea? Has anyone threatened you or frightened you to force you to plead guilty? Other than this plea recommendation, has anyone promised you anything to get you to plead guilty? Are you under the influence today of any intoxicants like alcohol, drugs, narcotics, or prescription medications? Is your mind clear today? Do you know where you are and what you're doing? Can you read and write? Do you have any questions about anything that has happened up to this point? If you are not a United States citizen, a guilty plea will affect your immigration status. Mr. Owens, are you pleading guilty to count 1 under the First Offender Act to violation of the Georgia RICO statute, and count 16 under the First Offender Act to violation or to purchase, possession, or sale of marijuana because you are in fact guilty as charged? All right, Mr. Maxwell and Ms. Stanley, see that his guilty plea gets entered. Facts of the case, Ms. Stanley.
This case arose out of Operation Skyhawk 2 in Telfair County, and on or about the date in the indictment, we expect the evidence would have shown that Mr. Owens was driving a car with another co-defendant in it down here to Telfair County to a certain house where another co-defendant was waiting. Other co-defendants in that case had organized a prison contraband drop to Terrence Wingfield at Telfair State Prison, and that is the basis for the racketeering conspiracy count. The basis for the marijuana count is that some of the prison drop packages contained a large amount of marijuana that was intended to be introduced into Telfair State Prison.
Anything from the defense, Mr. Maxwell? Yes. Mr. Owens, do you have any questions about anything that has happened up to this point? Is there anything that you would like to say? You don't have to, but you can if you want to. Very well. The court finds that the guilty plea to counts 1 and 16 under the First Offender Act has been freely and voluntarily entered. The court finds there is a factual basis for the pleas, and the court will accept the recommendation as has been submitted, which will be the sentence of the court as follows on count 1. All under the First Offender Act, if I didn't say it already, but 5 years to serve, credit for the time served as was stated, and the balance of 4 years and 149 days will be suspended, which would be lifted upon anybody.
Not at all. Judge Reeves. We used to watch Judge Reeves on this channel all the time. He doesn't stream anymore, and he's not going after his seat again this year when it's up. because of scandal. But his accent was the most delicious, period. It was such a great accent.
Violation of probation or any new offenses. And count 2 will be 5 years probation consecutive to count 1, $700 fine plus the add-ons that go with it. Both probationary parts of the sentences will be served under drug and alcohol conditions, Fourth Amendment waiver conditions. You have a period of 4 years to file a habeas corpus petition from the date the sentence becomes final, 30 days to file a notice of appeal or a motion for new trial. Do you possess a concealed carry permit for a handgun? Special gang conditions will be applicable, be banned from all DOC facilities except while, of course, you're serving any DOC sentence, and no contact with any listed co-defendants. Did I check all the boxes, Ms. Stanley?
You did.
All right, Mr. Owens, that will complete this case. You are remanded back to the custody of the sheriff to begin execution of your sentence. Good luck to you, sir. Mr. Maxwell, any other business with you today?
Same. So, the people in the RICO cases in Georgia have been sitting in jail for years and years and years without being indicted. And the cases just don't move forward. So we finally got a sentence on one RICO charge in Georgia, which is crazy. Because these people didn't even get a lawyer till a year and a half went by. Then they got a lawyer. They just sat in jail, in Georgia jails. Can't be legal. I'm telling you, we should get a class action lawsuit together. We should do this for them. YouTube stopped talking to me. They're just ignoring me now. They're saying it's live chat. There's nothing we can do. No, that's not what they're saying. They're saying there is no issue. There's absolutely no issue if messages disappear because YouTube will always, oh my gosh, she is. Oh, that's my bad. Apparently she's telling me again, my live chat is disabled. Even though I told her, I just sent you a screenshot of my live chat. It's not disabled. Look, it's right there. You can see it. Look, we can all watch it. Let's just be sure. Oh, live chat. So, I'm going to keep fighting with YouTube. I don't know if I should shut this stream down, though. Because what if they do actually try to fix it? 627. All right, I'm going to shut the stream down. They're not helping me. I'm going to try again later when someone else is on. Maybe I'll do a members-only private stream with crazy, whatever stuff. Anything. Just so that I can chat with YouTube the whole time. All right, guys. Have a great day. Thank you so much for coming out. I appreciate it so much. I'll see you again tomorrow. Behave, okay? Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. a joy she can't hide.